know we often have to do this job with one arm tied behind our back. Too often it feels like we're the ones playing checkers while everyone else is playing chess. Just look back at a couple of years ago by the work done by our Special Investigative Committee on Oversight. That committee was charged with an incredibly important task and did an outstanding job. But in that process, we were able to see some clear examples of where our investigative authority falls short. After seeing the process and talking with many members who serve on the committee, it's clear their job would have been far less challenging if they possessed all the tools they should have had. During that investigation, we saw a witness who did not want to testify, who provided partial or misleading information, and even a witness who testified about some event but provided two totally different contradictory stories. In all these instances, House Bill 2374 could have helped the committee to compel meaningful testimony from a witness who had information vital to the investigation. I modeled this bill after similar authority possessed by Congress and modernized the language to work with our statutes, along with the chairman and the ranking minority member of this committee. It would allow the House of Representatives to compel testimony from someone who refuses to do so. This is a powerful tool, one that would be used only when absolutely necessary and only when a majority of the body authorizes it. In effect, it would allow the House to offer immunity for criminal prosecution to those who can provide vital information, the kind of information that can lead to the truth being uncovered. For anyone who has heartburn about the authority of this magnitude, keep in mind that Congress has this ability on the federal level, and it has been thoroughly vetted at all levels and upheld by the courts. We have existing state statutes that allow testimony to be compelled in this way. Keep in mind that this power cannot be exercised unless the body approves it, which means it will only be utilized when absolutely necessary. It's also important to note that the bill does not grant total immunity. Instead, it is balanced to ensure that testimony cannot be used to prosecute the witness in a later criminal trial, as well as to meet all constitutional requirements. House Bill 2374 also creates a new crime, contempt of the General Assembly. This crime is modeled after federal contempt of Congress law. It's meant to be a check on a witness who appears but refuses to answer a direct question. Again, this is a tool that has been thoroughly vetted and is very similar to the contempt authority of a judge who has, when dealing with the trial witness that does not answer a question. House Bill 2374 also sends a strong message that is meant to deter individuals from coming before the body and providing false testimony or acting to derail an ongoing investigation. It would stiffen the penalty for committing perjury before this body to a Class D felony, and create stronger penalties for such things as tampering with a witness or interfering with a legal process. These tougher penalties will send a clear message that false and misleading testimony will not be tolerated by the General Assembly. And if a perjury offense does occur, House Bill 2374 will ensure little to no politics are involved in deciding whether to prosecute the offense. Under current law, the House would hand over potential perjury offense to the local prosecutor, who would then decide whether to prosecute. House Bill 2374 keeps that in place while also giving the Attorney General concurrent original jurisdiction. More importantly, House Bill 2374 allows the Speaker or the President pro tem to request an independent counsel be appointed by the court. The independent counsel will have full prosecutorial discretion and sole jurisdiction. With this, we can make sure the process is free from political influence, and that could be exerted by any of the branches of government. This would allow us to be sure that perjury charges will or won't be prosecuted based on the merit and not because of political affiliation. I think these are simple but important changes based on lessons we learned during the SICO hearings in 2018. We aren't trying to invent the wheel here. We've simply taken what works at the federal level and applied it here in an effort to put some actual teeth in our investigative authority. Over the last few days, we've seen our former governor do a number of interviews with media where he has called into question the actions of the SICO committee. Everyone here knows that that committee did honorable, admirable work. But we also know there were limits to what they could accomplish. Our former governor has brought up the fact that our committee was never able to determine the origins of a $120,000 payment. He claims the committee ignored that component of the investigation. But the truth is the committee had no way to compel that kind of testimony that could have uncovered the truth. I do agree with our former governor and his family that the people we serve should know and should learn the origins of the $120,000 payment. With that said, had the committee possessed some of the tools that are in this bill, maybe that would be a different story, and today we would have answers the people deserve. And even if it's not a silver bullet, at least it's a step in the right direction to give this body the kind of authority it needs to conduct meaningful investigations. I am a true believer when it comes to the importance of checks and balances and the oversight component of the legislative branch has over the other branches of government. Let's make sure that the future legislatures have the tools to do their job properly so the best interests of the public can be served. With that, Mr. Chairman, I appreciate the time, and I will take any questions.
Thank you, sir. Thank you, Mr. Floor Leader, so much for bringing this bill. And I do want to make it clear to the committee that our floor leader has worked very, very closely with both me and Representative Mitten on making as many changes as we can. I can tell you I've sat down with him, and he's just been very clear, very transparent that he wants us to be absolutely as fair as possible. So thank you so much for doing that so far. And at this point, we are very open to additional comments or questions that you may have. So anybody questions for the floor leader? Representative Mackey.
Thank you, Mr. Chair. Just a quick question. When I read it, it seemed to be modeled pretty succinctly with the congressional law. Is there any difference between what we're trying to put in place here and what exists at the congressional level in terms of compelling testimony and providing immunity in order to negate the necessity for the Fifth Amendment?
So just so you know, I am not an attorney, and I've been working closely with many different attorneys on this issue. As a matter of fact, this last draft that you have sitting in front of you, we didn't get till 10 o'clock this morning. But as far as and I will get this to the committee, but there are state statutes that, if you don't mind, I'll read this for you. There are several Missouri statutes that compel testimony over the assertion of privilege against self-incrimination. Such statutes require a witness to testify or produce information, but provide immunity against such information being used in any criminal proceeding against them. The following sections allow for testimony to be compelled in certain proceedings. Now, this isn't all of it, but we just found a couple of state statutes that already include this action. Section 198.177, nursing home Medicaid fraud investigations. The next one is unemployment benefit cases. The next one is insurance investigations. The next one is merchandising practicing investigations. The next one is Uniform Securities Act investigations. Any proceeding before a court or grand jury. Examination of debtor to executed judgment. I've got some Supreme Court cases also listed in here that I'd be happy to provide you with.
Okay, great.
Yeah,
thanks.
Absolutely.
Appreciate it.
And just to simply address that, Representative, it is modeled after and follows pretty closely, but it's obviously a little different from the federal system, only a little bit. But yeah, you know, the federal system's got the proffers with either limited or absolute immunity, and what you're seeing here, the way this is drafted, is at a state level absolute immunity. So anything even derived from that testimony cannot be used against them in the future. So that's very, very powerful. It very much protects any witnesses that are compelled to speak against their self-incrimination right.
If I might add, Mr. Chairman, we go as far as some of the additional barriers that I've put in here so that we don't have, you know, a speaker, whether it's today, tomorrow, 10 years from now. This bill does give the before you can compel, you have to go to the floor of the House of Representatives and plead your case in front of our body, and it has to be a vote of the body. We've got to get a majority of the entire body to agree to compel.
Further questions for the floor leader? Seeing none. Sir, do you have anybody here to testify in favor?
I'm not aware.
That's all right. Any witnesses here to testify in favor of the bill? Seeing none. Anybody here to testify in opposition of the bill? Seeing none. Anybody here to testify for informational purposes only? Seeing none, sir, you may conclude.
I appreciate your consideration. Thank you for hearing me out, and I look forward to talking with you outside of this room. Appreciate it.
Thank you. This concludes the hearing on House Bill 2374. Okay. We are going to move into executive session. We're going to start with House Bill 1332. I now move that House Bill 1332, sponsored by Representative Veet, be voted do pass. Any discussion? Representative Mackey.
Thank you, Mr. Chair. I have an amendment ending in .01H that's been distributed, and I move for its adoption.
Representative Mackey moves for the adoption of House Committee Amendment 1 ending in .01H. Representative Mackey.
Thank you, Mr. Chair. This amendment moves the penalty for the offense from a Class D felony to a Class E felony. Most tampering is a Class D felony, but I think this particular tampering of not having your device charged or plugged in is a little less severe than other forms of tampering that might exist. And so I've talked to the bill sponsor, Representative Veet. He was open to this, something we talked about earlier, and I hope the committee will support it as well.
Further discussion? Representative Veet.
He did discuss it with me, and I am in favor of the amendment.
Very good. Further discussion on the amendment? Seeing none, Representative, do you renew your motion?
I renew my motion.
Representative Mackey's renewed his motion to adopt House Committee Amendment 1. All those in favor say aye. All those opposed say no. The ayes have it. You have adopted House Committee Amendment 1. Any other discussion? Seeing none, I now move that we roll the amendment into a new House Committee substitute and adopt the substitute. Any discussion on that? Seeing none, all those in favor say aye. All those opposed say no. The ayes have it. We have rolled the amendment into a new sub and adopted the sub. I now renew my motion to do pass House Committee substitute for House Bill 1332. Madam Secretary, please call the roll.
Chairman Gregory.
Aye.
Vice Chair DeGroat. Representatives Mitten. Cristofanelli. Coleman. Ellebrock. Evans. Hicks. Hill. Kolkmeyer. Mackey. Roberts. Sauls. Shore. Tolson Wright. Trent. Veet. 15 to 1. 15 to 1.
By your vote of 15 ayes and 1 no, you have voted do pass House Committee substitute for House Bill 1332. I now move that House Bill 1952, sponsored by Representative Trent, be voted do pass. Discussion. Representative Trent.
Thank you, Mr. Chairman. I have an amendment, ends in .05H. It's been distributed, and I move for its adoption.
Representative Trent has moved for the adoption of House Committee Amendment 1 ending in .05H. Representative Trent.
Thank you, Mr. Chairman. This is the amendment that was alluded to in testimony last week. It has a technical correcting amendment, deletes number 2 and inserts in lieu thereof number 3 on page 2. Which is the part that points to the subsections that the bill refers to. Based on the discussion that we had in committee last week, the 30-day notice period has been extended to 45 days in an attempt to give a little bit of additional leeway for folks who are looking for notice to be able to act upon that notice. And finally, the amendment would allow proof that the request was delivered via a nationally recognized courier service in recognition that there are many notice delivery systems that do not utilize the postal service but utilize other carrier services. I think that makes sense to give folks the most flexibility possible when complying with the notice segment. If there are any questions, I'd be happy to answer them. If there are no questions, I renew my motion.
Further discussion? Seeing none, Representative Trent has renewed his motion to adopt House Committee Amendment 1. All those in favor say aye. All those opposed say no. The ayes have it. You have adopted House Committee Amendment 1. Any further discussion? Seeing none, I now move that we roll the amendment into a new House Committee substitute and adopt the substitute. Any further discussion on that? Seeing none, all those in favor say aye. All those opposed say no. The ayes have it. We have rolled the amendment into a new sub and adopted the sub. I now renew my motion to do pass House Committee substitute for House Bill 1952. Madam Secretary, please call the roll.
Chairman Gregory.
Aye.
Vice Chair DeGroat. Representatives Mitten. Cristofanelli. Coleman. Ellebrock. Evans. Hicks. Hill. Kolkmeyer. Mackey, Roberts, Sauls, Shore, Tosin Wrights, Trent, Veet, 17-0.
By your vote of 17 ayes and 0 noes, you have voted do pass House Committee Substitute for House Bill 1952. I now move that House Bill 2139, sponsored by me, be voted do pass. Any discussion? Seeing none, I renew my motion to do pass House Bill 2139. Madam Secretary, please call the roll.
Chairman Gregory,
Aye.
Vice Chair DeGroat, Representatives Mitten, Cristofanelli, Coleman, Ellabrock, Evans, Hicks, Hill, Kolkmeyer, Mackey, Roberts, Sauls, Shore, Tosin Wrights, Trent, Veet, and to clarify, Mitten,
She was a no.
to make sure, 12-5.
By your vote of 12 ayes and 5 noes, you have voted do pass House Bill 2139. I now move that House Bill 2241, sponsored by Representative Hicks, and sponsored by me, and 2244, sponsored by Representative Hicks, be voted do pass. Any discussion? Okay. Okay, so I'm moving for the adoption of House Committee Substitute 1, ending in .03C. Okay. So discussion on the House Committee Substitute. All I'm doing is taking the exact two bills, we're rolling them into one, so that Representative Hicks and I can carry that sub together. Question on the BSL sub. Discussion on it. Representative Mitten has moved for the adoption Representative Mitten has moved for the adoption of House Committee Amendment 1 ending in .01H. Representative Mitten, feel free to discuss that with us.
Thank you. So, Mr. Chair, all this amendment does is it says that breed-specific ordinances will not be legal unless the city, town, or village decides to put it to a vote of the people. I'm not offering this amendment because I have a specific problem with the substance of this bill that I know Representative Hicks has been filing since our first years here in the General Assembly. But I do think that I do have an issue with the principle of this body, not necessarily this committee, but we certainly do it here as well, taking local control for granted on a pretty consistent basis. And I would laugh back at home about the fact that we like local control except for when we don't. And my concern is that it seems that we are increasingly removing local control. And I think it's kind of interesting that I seem to have become the Democrat that wants to remind my friends and colleagues on the other side of the aisle about what big government actually looks like. And to me, big government looks like the state telling a local political subdivision that they don't have the right to control their own destiny with respect to something that really doesn't impact the state or public safety. So this would be just one example of the ways in which, if the folks that live in Richmond Heights does not have a breed-specific ordinance, I don't think we've ever had one, and I've lived there for 25, 30 years. But if the good people that I live with in Richmond Heights wanted to have one, I don't know that this body or the General Assembly should be in the position of saying that they can't. But I don't have a problem saying, but you got to do it by the vote of the people. So that would mean that the local city council and mayor and all those folks would have to put it on the ballot. They would have to be accountable to their taxpayers and voters as to why they decided that this was something so important that they were willing to pay up for putting something on the ballot, because we don't put things on the ballot for free. But it does mean that if for some reason there was a desire to have local control over something like the kinds of dogs that we live next to, that the voters in a particular political subdivision would have that right. Thank you.
Okay, further discussion. I'd just like to make a comment. I do really appreciate Representative Mitten's amendment. I do, but I don't see this as big government. I see this as preventing overreach. I see it as something much different than big government. I see it as reducing government by forcing the lessening of overreach from local government. So I am, as much as I appreciate the representative, I am opposed to the amendment. Any further discussion on Representative Mitten's amendment? Representative Hicks.
Give my opinion on the amendment. She did bring this to me to talk to me about the amendment. Representative Mitten did. And after looking at the amendment and looking it through, I still see where the BSL language is still in there. And I want to make another point here. As far as local control goes, all we're asking is you don't make it breed specific. Local control can still make up their own laws if they want to make it to where they're neutered or they're muzzled or whatever they have to do, the leash laws, all that stuff. We're just asking you do not make it breed specific. That's all.
Further discussion, Chair DeGroat.
To speak to either one of the, or inquire of either one of the bill sponsors, whoever feels motivated or inspired by my question can answer it. Isn't one of the purposes of this bill to get rid of selective enforcement? In that it is, first off, it's tough to identify which dogs truly are pit bulls and to what degree, right? Because dogs mix. And sometimes you get a dog that's a half pit bull or a quarter pit bull and still has the same facial characteristics of a dog, but of a pit bull, but it really isn't a pit bull. Is that correct? I'm not a veterinarian.
Yeah, go ahead.
Well, you bring up a very good issue, and one of the issues is I think it was back in maybe 2004 or 6 when Springfield did theirs, and they talk about how a pit bull mix. Okay, well, what is a pit bull mix? That means 1% DNA would be a pit bull mix.
Right, and how would this amendment fix that? It wouldn't, would it? We'd still have the same problem of selective enforcement.
Yeah, exactly. The amendment fixes nothing as far as what the bill is trying to accomplish.
All right,
to be perfectly honest.
Thank you.
Further discussion on the amendment? Seeing none, Representative, would you like to renew your motion?
Yes, I would, and I'd ask for a roll call vote.
Okay. Representative Mitten has renewed her motion to adopt House Committee Amendment 1. She has also requested a roll call vote, which I will grant. Madam Secretary, please call the roll.
Chairman Gregory?
No.
Vice Chair DeGroat? No. Representatives Mitten? Yes. Cristofanelli? Coleman? Ellebrock? Evans? Hicks? No. Hill? No. Kolkmeyer? No. Mackey? Yes. Roberts? Yes. Sauls? No. Shore? No. Tosin Wright? No. Trent? No. Beat? No. Ellebrock? 4 against 13. 13 against.
Got it. I got it. By your vote of 4 ayes and 13 noes, you have failed to adopt House Committee Amendment 1. Further discussion on the House bill. Seeing none, I renew my motion to do pass House Committee substitute for House Bills. No, I do not.
Have to adopt the House Committee 7. He's not adopted.
I apologize. Okay. I apologize. I renew my motion to adopt House Committee substitute for House Bills 2241 and 2244. All those in favor say aye. All those opposed say no. The ayes have it. You have adopted House Committee substitute for House Bills 2241 and 2244. I now move that we do pass House Committee substitute for House Bills 2241 and 2244. Madam Secretary, please call the roll.
Chairman Gregory?
Aye.
Vice Chair DeGroat? Aye. Representatives Mitten? Cristofanelli? Coleman? Ellebrock? Evans? Hicks? Hill? Kolkmeyer? Mackey? Roberts? Sauls? Shore? Tosin Wright? Trent? Beat? 16 to 1.
By your vote of 16 ayes and 1 no, you voted do pass House Committee substitute for House Bills 2241 and 2244. I now move that HCR 74 be voted do pass. Any discussion?
I mean, I'll just, House Concur Resolution 74 condemns the 1852 Dred Scott decision, which is a negative legacy for the state and antithetical to the nation's founding values, specifically the tenet that all men are created equal, and I appreciate everyone's support on the resolution.
All right. Any further discussion? Seeing none, I renew my motion to do pass HCR 74. Madam Secretary, please call the roll.
Chairman,
Back up 1 second. Chairman DeGroat.
Maybe asleep at the switch. I move that we treat this as a consent bill. Nope. Never mind. I withdraw that.
Very good. Chairman DeGroat withdraws his outstanding thought. I now renew my motion to do pass HCR 74. Madam Secretary, please call the roll.
Chairman Gregory.
Aye.
Vice Chair DeGroat. Representatives Mitten. Cristofanelli. Coleman. Ellerbrock. Evans. Hicks. Hill. Kochmeyer. Mackey. Roberts. Sauls. Shore. Tosin Reitz. Trent. Beat. 17 to 0.
By your vote of 17 ayes and 0 noes, you voted do pass HCR 74. I now move that House Bill 2216, sponsored by Representative Coleman, be voted do pass. Any discussion? As a matter of fact, I actually move for the adoption of House Committee Substitute 1 ending in .04C. You all would have just received that. Discussion on the House Committee Substitute. Representative Coleman, if you could talk to us about it.
Sure. Thank you, Mr. Chairman. The language that is changed in this House Committee sub is the result of continuing conversations to tighten up and make sure that we have agreement from all stakeholders. There are no significant changes in this House Committee substitute that were not mentioned in the hearing, with the exception of the following provisions. There was a concern that the definition of a carve-out for contracted care providers could include all residential treatment providers. That's not the intention of the bill. The intention is to have a carve-out for medically frail who are going to be requiring 24-hour service on an ongoing basis, so that is clarified. The second piece that's in this committee substitute that was not discussed in the committee hearing 2 weeks ago is currently our schools are the only exempted entity from investigating themselves when there is an allegation of abuse that is made against them. This treats all parties equally and doesn't provide that exemption from our schools. And the necessary stakeholders are all in agreement with that change as well. There are quite a few small technical changes in that bill, as well as some in an amendment that will be offered later in an effort to continue to make sure that we're getting buy-in from all necessary stakeholders for such a significant undertaking. Thank you, Mr. Chairman.
Questions on the sub, Representative Mitten?
Actually, just really wanted to make a comment. I wanted to thank the sponsor and all the other hands that have that have been involved in this. And I really particularly want to thank the sponsor, as much as I was maybe frustrated on Saturday about getting a bill that I had to read. I am grateful for her willingness to continue to talk about this bill and to fine-tune it. And although I think there are still a couple things that need to be addressed, I'm confident that we will work on those together and with others, and that by the time we get to the floor, we'll have a couple of amendments that will pass swimmingly. So I support her bill, I support her efforts, and look forward to continue to tweaking it. Thank you.
Further discussion on the substitute. I move for the adoption of House Committee Amendment 1. It ends in .02H. If you can pull up that amendment, we will discuss that. Let's, Representative Coleman, please explain that amendment.
Thank you, Mr. Chairman. As I mentioned, there were a number of changes that did not get rolled up into the House Committee sub because at some point we have to close the drafting to get it out of publications. These were subsequent findings that happened. As Representative Mitten said, we will continue to find those changes on such a significant rewrite, so expect to see more cleanup language on the floor, but this is an effort to continue to move in a positive direction.
Further discussion on the amendment. Seeing none, I renew my motion to adopt House Committee Amendment 1. All those in favor say aye.
Aye.
All those opposed say no. The ayes have it. You have adopted House Committee Amendment 1. Further discussion. Representative Mackey.
Thank you, Mr. Chair. I'd like to offer an amendment ending .03H that's been distributed. I move for its adoption.
Representative Mackey has moved for the adoption of House Committee Amendment 2 ending in .03H. Representative Mackey, please explain that one to us.
Thank you, Mr. Chair. Talked this over with the sponsor recently, and this was I got it to her a little too late before, the drafting was done on the sub. This clarifies, since deals with the whistleblower protections, since the identity of the whistleblower is concealed as it should be at trial. We want to ensure that whoever is investigating has no connection or any implicit or explicit bias connected to either of the parties, including the whistleblower or the accused. And so this language simply clarifies what should already be the case, and hope the committee will support it. And renew my motion.
Representative, you've spoken with the underlying bill sponsor?
That's correct. Yes, and she is approved. She supports it.
Very good. Any further discussion on the amendment? Representative Coleman.
Just to echo that, thank you to the representative for working with me on this, and I support the amendment. I don't know what implicit bias is, but I support the underlying amendment.
Further discussion on the amendment? Seeing none, Representative Mackey, do you renew your motion?
I renew my motion.
Representative Mackey's renewed his motion to adopt House Committee Amendment 2. All those in favor say aye. All those opposed say no. The ayes have it. You have adopted House Committee Amendment 2. Further discussion? Seeing none, I now move that we roll the amendments into a new House Committee substitute and adopt the substitute. Any discussion on that? Seeing none, all those in favor say aye. All those opposed say no. The ayes have it. We have rolled the amendments into a new sub and adopted the sub. I now move that we do pass House Committee substitute for House Bill 2216. Madam Secretary, please call the roll.
Chairman Gregory?
Aye.
Vice Chair DeGroat? Representatives Mitten? Christopher-Nelly? Coleman? Ellebrock? Evans? Hicks? Hill? Klockmeyer? Mackey? Roberts? Sauls? I'm sorry. Shore? Tolson Wright? Trent? Feet? 17-0.
By your vote of 17 ayes and 0 noes, you voted do pass House Committee substitute for House Bill 2216. That concludes the executive session. We're now going to move back into public session, and we are going to first hear House Bills 1972, represented by Chair DeGroat, and House Bill 2366, sponsored by Representative Bosley. Thank you.
All right. Good afternoon, Chair and committee members. My name is Bruce DeGroat, proud representative, District 101. Thank you for allowing me to present House Bill 1972 regarding marriage license and recorder of deeds. I am going to be very brief, as I believe that this is a very simple bill that would allow a recorder of deeds to accept marriage applications and approve them through a secure online process. It truly is just a bill that brings us into the 21st century. I am a big proponent of bills that are presented to us by people who actually live with these systems on a day-to-day basis. I have a star witness who some of you may know, former Representative Michael Butler, who is a recorder of deeds, and he is here to explain all the ins and outs. I'd be happy to answer any questions, but in all likelihood, I'll defer them to him. So with that, if you have any questions, I'll take them. Oh, and thank you, Representative Bosley.
Representative.
Hello.
Thanks.
Sorry for being late, Mr. Chairman. I had a little girl's emergency.
Well, I'm not going to argue with that. If you'd like to take a minute or two and also update us on your bill before we open you up for questions.
I just thank the committee for hearing the bill, and I just agree with everything Representative DeGroat said.
Outstanding testimony.
All the time. I want to thank the representative for working closely with me on this. Thank you.
All right, very good. Questions for the bill sponsors? Seeing none, thank you both for being here. Chairman DeGroat, will you call your first key witness for us?
I would. I believe I only have one. Former Representative Michael Butler, please step forward and explain what this bill is all about. You bet. Thank you.
Mr. Recorder.
Hey,
Is that
everybody.
is that how I can address you, Mr. Recorder?
That's perfectly fine.
All right, very good. Well, welcome back to the House of Representatives.
Glad to be here. Glad to be here. Thanks. Thank you, Mr. Chair, to Mr. Chair and the Ranking Member Mitten, and of course the Vice Chair and sponsor Bosley for hearing me, and the rest of the committee for hearing the bill today, House Bill 1972 and 2366. House Bill 1972 and 2366 provides recorder deeds to accept marriage applications and approve them through a secure online process. This process includes verifying applications through a widely used two-step verification process. As we look to modernize the St. Louis City Recorder Deeds Office and the offices across the state, we believe that this bill will benefit the people we serve with more efficiency. It's important to know what this bill came about is that our office is the only office in the entire state that handles both marriage licenses, land deeds, birth records, and death records. In all other counties across the state, birth records and death records are handled through your local Department of Health. Our office already does birth records and death records online through a two-step verification process. We are a contractor of the state government that utilizes a system called Vital Check that uses a two-step verification process, as well as other processes to verify people are who they say they are when they get their birth certificate and death certificate. Every other county in the state, you can get your birth and death record online. This bill brings the recorder's office up to date. It's 2020, and a lot of people want to be able to access their government online. You can get a bank account online. You can transfer money from one bank account to the other bank account online. You can register to vote online. You can do a lot of other things online. We are hoping that you can also apply for a marriage license online. There is a piece of statute that requires that you are in the presence of the recorder deeds or their deputy in order to conduct business, in order to apply for a marriage license in the state of Missouri. We're hoping that we can change that to add an option, not mandating any county to do anything, but for counties to be able to determine they want an option to create an online process for their county. And with that, I'll open up to any questions.
Thank you very much. So it's my understanding you already have the infrastructure set up to process these applications online?
This is correct.
So there will be a zero fiscal note?
That is correct.
Okay. Further questions for the witness? Representative Kolkmeyer.
To inquire.
Proceed.
Good afternoon, Representative.
Good afternoon,
Recorder.
I'll take either one.
Okay. Well, I'm glad we finally have you in the hot seat.
Uh-oh.
Have you been working with the state associations of recorders?
I have, and I believe they'll testify today. We took a trip around the state and talked to many different recorders about how this would affect them and how they feel about online marriage, online process, and I'm sure the Recorder Association will speak for themselves today.
How many outstate have any type of electronic records?
So, well, that's a great question. When it comes to what is known in our industry as e-recording, that is recording land deeds online, I would say about 80% of our counties, and I'll let the Recorder Association speak to that specifically, but I believe about 80% of our counties have e-recording. That was a huge deal and for over the past 30 years. Actually, my predecessor was one of the first in the state to do e-recording a long time ago. When it comes to birth and death records, as I said, receiving those records online is only done through our office as a recorder deeds. They're online fully within the entire state through Department of Health.
Okay. Thank you. Good to see you again.
Good to see you again, too. I thought I was going to have to plead the fifth or something. So
Further questions for the recorder, Representative Mitten. Proceed.
Hey.
Hey.
So my only concern, and my brain just kind of like light bulbs out sometimes, is like I think you were still here when we passed the you can't get married when you're 14, even with a court.
It was a co-sponsor.
Okay, that's what I thought.
Yes.
So I guess that's my concern is how is it that how do you verify? What does that look like for folks that are worried that some wanderlust kids try and fake it?
So I think there are two parts to answer that question. One is that let's say folks are telling the truth and they are on the application, and one person says they're 26 and the other says they're 14. We electronically we will be able to not allow the application to go through.
Then they try again.
Now let's say that. So let's say that they also so that they lie on their application. They say that they're different ages. Vital Check and other verification companies are able to determine whether those folks are by two ways. One, you can upload your actual identification, where we would, just as you view your identification in person, we can view your Vital Check or ourselves directly in the office, review the identification ourselves. Or what it also does is it asks you a series of questions and two-step verification. So if you say what your name is and you say your date of birth is incorrect, it'll pop it back. It'll pop it back automatically and say that this isn't. Michael Butler is not born in 1976. I'm born in 1986, and they will not be able to apply online. So there are several different questions that you have to be answered in the second step that you have to even if that first step is correct, that you have to verify whether you own a certain car. If you're 14, you probably haven't owned a car. If you had a certain address in the past, things of that sort you do with a bank account, that they just most likely wouldn't pass.
So they basically have some sort of like algorithm to ask a series of questions to ensure that it's based upon available public records to ensure, like, they'll know that Michael Butler has a 2016 Chevy registered to his name, or
companies like Vital Check have access directly to the Department of Revenue, IRS, as well as all. This is why there are very few of them. All access to all state, federal, and local databases where they have pretty much all the information they need on you to determine where you are who you say you are.
And then one last piece, and I apologize because I don't know, because I mean, I've read the bill and I don't know if it's someplace else. Would a recorder or would it? I'll get this out. If I want to get a marriage license electronically, is it going to cost me any more than if I show up in person?
It is. It will.
Okay.
It will absolutely be. There will be extra fees on that. Either the two-step verification company would charge, or there may be some counties can charge extra fee that they'd want to charge themselves for a convenience fee. That it most likely will be more expensive based on what the county decides to charge.
And who they're contracting with.
Correct.
And then do we not have to go and address that someplace else in statute? In other words, do recorders, and I'm not trying to pick on recorders specifically, but do you guys just have the ability to add whatever fees you want to without us?
We don't have the ability to increase the marriage license fee, so that in statute how much we can charge for an actual marriage license, but for convenience of being online or convenience of doing something over the phone as has been done in the past, not with marriage license, but with other documents. We do the local recorders have the ability to pass extra fees on those.
To just do that. Oh, okay, interesting. Learn something new.
I would say it's the local county has the ability to do that, but recorders can't just. We don't make up fees ourselves to be able to charge.
Right, but so I guess in your case, so the board, the city of St. Louis would have to pass them something to ensure that's kosher. Okay, thank you very much. Good to see you. Thank you, Mr. Chair.
Further questions for the recorder? Seeing none, thank you so much for being here, sir.
Thank you all.
Is there any witnesses in opposition of these House bills? Seeing none, let's go back to those in favor. Next witness in favor of these House bills.
Chair, members of the committee, Jessica Petrie here on behalf of the Recorders Association of Missouri. We very much appreciate Recorder Butler's work on this, as well as the representatives. We have worked with the sponsor as well as the proponents on some additional language that we think is helpful to make the bill stronger. One, requiring two-step identity verification, which former Representative Butler, still hard to keep that straight, referenced during his testimony. And the second change we recommended was, we don't want, if there are only one or two counties in the state who offer electronic licenses, we don't want everybody from in the state to be rushing and glutting one or two county systems. So we've also proposed language that would say that in order to use the electronic process, at least one party to the marriage has to be a resident of the county that is using the electronic process, just to prevent a rush to the one or two counties that may be offering this service. But we are in support of the bill and really appreciate all of the work that they have put into this.
Thank you so much. Questions for the witness? Seeing none, thank you so much for being here. Next witness in favor? Seeing none. Anybody here to testify for informational purposes only? Seeing none. Representatives, 1 minute to close.
I don't think you'll need it. I'll just, on behalf of Representative Bosley, thank you very much for your time and consideration.
Thank you. Thank you both. This concludes the hearing on House Bills 1972 and 2366. We will now hear House Bill 1996, sponsored by Representative Wilson. Representative, please proceed when you are ready.
Thank you, Mr. Chairman and committee, for allowing me to present this bill. Representative Ken Wilson, District 12. This bill is, and I can't believe I'm going to say this, is a simple bill. It just simply brings county sheriffs to the same level as the Department of Corrections. Currently, if you're in a Department of Corrections, you have to exhaust all administrative rules until you can actually file a lawsuit. That does not apply to county jails. So you get an inmate in your county jail, they don't like your rules, they don't like how you're running things, and there's a variety of those, then they sue you. And typically what happens is they don't like something and they sue you. Well, you go through the process. It comes down to it, the insurance companies or whoever's involved settles. The inmate gets a $200 paycheck to their commissary. The citizens get a couple of $3,000-$4,000 legal bill, and then away you go. This just simply brings county sheriffs up to the same level as Department of Corrections.
Okay, thank you very much, Representative. Questions for the representative? Chair DeGroat.
To inquire the witness, please. Thank you. First off, Representative, thanks for bringing this bill. I'm not as familiar with these types of cases as I am federal cases, and federal cases quite often are quite frivolous. Is that what you're experiencing? Like somebody doesn't like peanut butter because it got too many nuts in it or something like that? Is that the kind of stuff you're talking about?
I didn't want to say frivolous, but that's basically what it is. And by the time, and if they file it, you got to deal with it.
Well, and I don't want to characterize all of those lawsuits as frivolous because some of them have merit.
Some of them have merit.
What you're proposing still allows for those that do have merit to filter themselves up through the system. You're just saying you have to expire all of the available alternatives before you get to actually go to circuit court. Okay,
exactly.
Thank you.
Further questions for the representative? Seeing none, thank you so much for being here, sir. First witness in favor of House Bill 1996.
Thank you, Mr. Chairman, member of the committee. My name is Eric Holland. I am the Undersheriff and General Counsel for the Platte County Sheriff's Office out in the Kansas City metro area. Testifying in support of the bill. In preparation for this hearing, I actually talked to some of my colleagues in the law enforcement defense industry. In speaking with one attorney, I came across a single inmate that since 2016 has sued various county entities over 20 times on these type of lawsuits. You're seeing now where they're filing lawsuits saying that they don't have to exhaust remedies because it's not required by Missouri statute. If a county inmate sues in federal court, they have this exhaustion requirement. It does not exist if they sue in state court. And in my own county's example, you'll forgive the language, but our most recent suit was a woman suing us because she says her uterus was falling out, despite doctors looking at her and telling her, no, this is not what's going on. She automatically gets right into circuit court, and we have the expenses of outside counsel and litigation to go through this issue, whereas if they go through a grievance process, a lot of these type of lawsuits can be disposed of before they ever go into the courtroom.
Very good. Thank you so much for being here, sir. I really do appreciate it. Questions for the sheriff? Representative Evans.
Just briefly, because I'm not familiar with it, what administrative processes or grievances would there be they would use to go to instead? I'm just not familiar with that process.
Each county has the ability of creating a grievance procedure where if an inmate feels that they are wronged in some way, shape, or form, they would go through an administrative hearing process to determine whether or not they are indeed wronged under the rules of the facility, or if the matter could be resolved outside of a court process. And depending on the county, they could have 1 level, 2 levels, 3 levels. There's no magic formula as far as what they look like, but it allows the county government to deal with the grievances. And an example that I'll use is, it's a hypothetical one, but let's say an inmate has, like a MP3 player or something that gets damaged during a cell check. If they're going through a grievance process, the county would have the ability of reviewing it and saying, okay, yes, we accidentally broke this $20 piece of equipment, or no, we didn't, it was contraband, you shouldn't have had it to begin with. Right now, the inmate can just file directly in the circuit court, and the county will probably be out thousands of dollars just in attorney's fees dealing with something that could be resolved internally in their own processes.
So there would be, each county would need to set up its own separate processes? There's no statewide kind of system that would kick in?
Under either the state or the federal, there's no requirement that they have a grievance process. So if a county elected not to have a grievance process, then the inmate would have no barriers to going directly into suit.
All right. Thank you for your service.
Yeah, thank you.
Further questions for the sheriff? Seeing none, thank you so much for being here.
Thank you, sir.
Next witness in favor.
Good afternoon. Thank you for having me here. I am Kevin Merritt, Executive Director with the Missouri Sheriff's Association, and on behalf of our membership, we'd like to go on record in favor of this bill and be happy to answer any questions.
Very good. Thank you so much for being here, sir. Questions for the witness? Seeing none, thank you so much. Next witness in favor. Seeing none. Any other witnesses in opposition of House Bill 1996? Seeing none. Any other witnesses for informational purposes only? Seeing none, this concludes our hearing on House Bill 1996. We will now hear House Bill 1937, sponsored by Representative Hill. Representative, please proceed when you are ready, sir.
Thank you, Mr. Chairman, Ranking Member, and fellow members of the committee. Justin Hill, 108th District. I represent Western St. Charles County. The bill I have before you today is House Bill 1937. Some of you may remember the last few weeks ago passed around a letter to send to the Supreme Court requesting that they rescind the rules that were made effective on July 1st of last year. Those rules pertain to changing pretrial release. But I need to go back a year or two before that letter, because last year one of our colleagues, Representative Roberts, I believe, filed House Bill 666, which did the exact same thing as the Supreme Court did. I've heard from several of my constituents, heard from several of your constituents, how this has more or less become a catch and release situation now. People are reoffending pretty quickly after they are released. And so I thought, you know what, we need to have this discussion. However, we did not get an opportunity to have this discussion because it was effectively legislated by the Supreme Court through their rulemaking process. So that letter was to request that they rescind the rules, come to the table, work with the people's representatives to come up with some good reforms. And I will add this. I do have a good history on criminal justice reform. We've passed good bills bringing this back to defend the public in an over-oppressive private probation program that we implemented here in the state. I am for criminal reform. However, we've gone too far, or the court has gone too far. And I want to repeal these rules and to have that discussion. So I will have, there's probably going to be a few people to testify, Mr. Chairman. I've instructed them not to be repetitive, so I believe that we're going to get a lot of good information out of our witnesses. I'm glad to answer any questions.
Very good. I appreciate that, Representative. Questions for the bill sponsor, Representative Tolson Reich?
Kind of a comment statement. So I was watching the national news last night, and New York with their catch and release program, they were showing a gentleman who has been arrested 139 times and released right back on the street. And my first thought was, is that what Missouri's going to become? And that's why I like your bill, and we need to work to rectify this before somebody is caught and released 139 times.
Thank you, Representative. It is, when word gets out, it changes people's behavior, plain and simple. In St. Charles County alone, after the rules were implemented, we saw a 30% increase of failure to appear. I mean, those are charges that will compound on people, and this is post Senate Bill 5. So we thank you for bringing that up.
Further questions for the bill sponsor, Representative Hicks? Proceed.
Thank you for bringing this bill forth, gentlemen. As one of the members from St. Charles County, we see a lot of this. So this is going to fix that, basically what I like to call the hotel check-in, check-out. So what you're telling me here is that this is going to repeal and fix the part that when an officer has arrested an individual and taken him to jail, we're not going to see him back out on the street again tomorrow. For certain offenses, obviously.
Not in those exact words. So what happened was they removed the cash bail program, essentially, and put it at the very bottom of the list. And they've ordered judges in all the circuits to say, try these non-monetary ways first. However, when you publish that and you kind of tie the hands of the judges, they don't get that option. We do want judges to have discretion, but we also need to keep public safety as a priority.
Yeah, I can see that, because it looks like right now we're just kind of letting them out without any process. So this is going to come down, well, who goes after them once they're let out?
That's a great point. So currently, there's not a huge demand for bail agents because there's no cash bail requirements. Okay? In the past, bail bond agents would come in, assess the risk, right? They didn't have to offer bail or bond. But once they assess the risk, they get to know the family members, they get to know the workplace, they can bail that person out. If they refuse to come to court, they have an incentive to go catch them, right? Because they're on the hook for that money. However, that was before, right? Now it's up to the sheriff's departments. And we've been talking to sheriff's departments about they can't afford to keep people in jail, number one, right, because of finances. Number two, they don't have staffing to go to Mexico to pick up a warrant, right? So we've essentially just kind of dumped this issue on the sheriff's departments across the state.
I can see, actually, there's a few sheriffs here, so I'll just save the rest of my question for them then. Thank you.
Further questions for the bill sponsor, Representative Mitten? Proceed.
So I'm assuming that you've actually read the rule?
I have read the rule.
The current rule?
Yes.
And unfortunately, I meant to give this to you before you. Well, here, I'm just going to come up and give this to you.
Is this Exhibit 1?
It actually isn't, so I apologize. I've provided this to the other members of the committee because this is a form that St. Louis County has adopted to deal with this very issue. And this form was, I don't do criminal law, so this form was brought to my attention from a judge that actually does not work in St. Louis County, who called me a few weeks ago and said, what's going on? This is not a problem for judges. I am required, as a judge, to go through the factors that are listed in Rule 33.01. I'm required to consider them. And if the prosecutor is able to convince me that there's a reason to have cash bail, I get to order cash bail. It's as simple as that. And this form that has been developed by the St. Louis County courts lists all of the factors that are outlined in Rule 33.01. And so a judge who is doing a criminal bail hearing in St. Louis County just goes through and says, yes, we have looked at these factors, and then you can continue on. It says, having considered these factors, the court finds the following least restrictive conditions are necessary to secure the appearance or secure the safety of the community. And then all the court has to do, if they feel that cash bail is warranted under the circumstances, list what that is. That's all that this rule does. It doesn't say you can't do it. It doesn't say you can't do it anywhere. All that it says is, if you're going to do it, you need to let us know why. What is the problem with that?
Well, ma'am, if you are okay with the Supreme Court legislating, that's one issue. They literally took a bill and made law. So that's number one.
So,
my
so
first
your
contention.
beef isn't with the policy. It's
So
with
the policy.
this
No,
is
let
a
me-
this is a
well,
constitutional
let me
crisis or a
finish.
separation of powers
the policy,
issue.
The policy, that is not what I'm getting from my constituents. That's not what I'm getting from your constituents, and that's not what we're seeing across the country where these policies were implemented, like New York.
Oh, well, as far as I know, these rules just came into being in the state of Missouri. I don't really care what's going on in New York. I care what's
July
going on in
1st.
our state.
July 1st.
July 1st. So we're what, 7 months out?
I have a 30% increase in failure to appear.
I don't know why that is. You're saying that this is why? Maybe talk to the judges. And one thing that I do think is a problem, and I do think this is a real problem, is that OSCA has not created this form. OSCA is still using the old forms, which does not list these factors. And I can get you a copy of the OSCA form if you want. And just says, having considered these factors, we find that it's necessary to secure the appearance or for the safety of others.
And standardization is a good thing. And that is one of the things we can talk about when these rules are rescinded. I want them to respect this body and allow our constituents to have a voice in the matter. They literally had a task force meeting where it was not open to the public. And I'm not okay with that, especially since this has been a bill for the last 2 years.
Right. So what you're not okay, but I guess what my concern is that what you're saying is you're talking a lot about the process being flawed. And believe me, you and I both know that we could go round and round and round about the process being flawed in a million areas of state government, including the building in which we sit.
I'm glad to hear
And in
that from
fact,
you.
I remember you saying last week on the floor, saying that every bill has unintended consequences. And, I know that we share those
The
concerns.
unintended consequence of not having a hearing on the gentleman's bill is them making law through rulemaking. And that is what I want to personally
Laws
see
are
go
made
away.
through rulemaking every single day by the division. Thank you, Mr. Chair.
Further questions for the bill sponsor? Representative Elbrock. Proceed.
I'm sorry, there's no convenient place to put this microphone. Sorry. I just want to be clear on a couple of things that, apart from the show there. You're not here to tell us or argue that the Supreme Court can't make any rules at all, right?
Right.
So the Supreme Court does have the authority to make certain rules.
Yes.
Okay. And if the Supreme Court made these rules, you think that these are rules that exceed the authority of the Supreme Court?
Especially when there was a bill filed the last 2 years. So I think the better process would have been them reaching out to the legislature, say, hey, we see this bill sitting out here. We want you to be a part of the task force. But they removed our voice, your constituents' voice. I mean, and obviously when we have constituents calling about, a rapist getting released the next day and reoffending, or, the shooting that was referred to in our letter that we sent out to the Supreme Court, I mean, that concerns me. We need to give them a voice.
No, I understand. I also know that the gentleman's bill that was considered last year wasn't advanced by the legislative body at all. So what's the court to do when the body doesn't advance legislation? I mean, because
Certainly not pluck it and make it law on their own.
But you'd agree that there are rules of evidence, isn't that right? There are rules of evidence in a trial, correct?
Yes.
Okay. So we've also changed certain of those rules of evidence to more conform to what certain interests in.
Which I understand they ignored.
So we can, well, not entirely.
Oh,
I mean,
they got to pick and choose those two.
well, if it's within the purview of their constitutional sovereignties, because we have three co-sovereign branches of government.
I know. We want all three to be respected.
And I'm not saying that what you're proposing here is wrong. I'm just saying that we're not I just want to be careful that we don't get into an argument about whether or not the Supreme Court has the authority to make rules. Clearly, they do.
They do.
Okay. Thank you. That's all. Thank you, Mr. Chair.
Further questions for the bill sponsor? Seeing none, thank you so much. Representative, call your first key witness in favor, please.
I'll call Mr. Jeff Clayton.
Mr. Clayton, please remember to fill out a witness form and proceed when you are ready, sir.
Mr. Chair, members of the committee, my name is Jeff Clayton. I'm the Executive Director of the American Bail Coalition.
which is a trade association of insurance companies who underwrite bail bondsmen throughout the United States. Work on this issue for numerous years, probably the better part of a decade, 30-some different state capitals I've been to working on it. So if it's happened in bail, I probably know about it. A couple of points to make. I think, the process was faulty. I think Missouri has one of the least restrictive court rulemaking processes of any I've seen in the nation. Having represented the Colorado judiciary for 5 years, we had a much more robust process where there were legislative appointees to the panel. Nonetheless, there was nothing here. There was no participation, excluding our participation, of course, but also important non-governmental interest groups like the ACLU and others that probably could have come up with some suggestions on how to improve this. And in having conversations about issues of bail in Missouri, I think the Supreme Court missed a large opportunity to make what I would consider to be some bipartisan changes. Second, I think the legislation does restrict judicial discretion. While there are ways around it, and the exception is there, I think it does set up a scenario which forces judges to reach a higher standard than they would have before. We advocate for leaving all bail, and conditions of release on a level playing field for judges with no presumptions for or against. And obviously, that you would think the bail bond industry would want to put presumptions for bail, but we don't think that's best practices. And so that's our primary objection to this legislation. And also the issue with obtaining a warrant and putting up evidence that somebody's a flight risk or danger to get a warrant, we think is also was an inappropriate change. And finally, I think the issue as to the risk assessment process, and we can talk more about that, but the Supreme Court has banned all risk assessments in Missouri, and I think that's a decision for you. We've heard that the old rules were unconstitutional. I've read the Dixon case. I went back and reread it again today. And to quote from the judge in the Dixon case, the gravamen of the complaint was that, quote, judges do not actually apply those principles in the rules or in practice. Considering both the old rules and the new rules, the judge in the Dixon case found that the bail procedures in St. Louis were constitutionally defective, which means that it's an issue of judges applying the rules, whether it's the old rules or the new rules. But to be fair, that issue is before the U.S. Court of Appeals for the Eighth Circuit, pending, argued December 12th, and we'll get a decision in a month or two. So we'll figure out what the Eighth Circuit's position is on the Missouri Supreme Court rules. Thank you.
Questions for the witness? Representative Eat.
You do acknowledge there is a constitutional right to reasonable bail, correct?
I do, yes.
And this procedure that was just handed out, Exhibit 1, allows a judge to go through and find those factors for basis for denying bail.
I haven't seen the procedure, but yeah, in the rules, there's a procedure for denial of bail.
You would want the judge to make a finding of why they deny bail, because it's constitutional right, you're entitled to bail. If they're going to take away your constitutional right and liberty, they ought to set forth the reasons why they're not doing it.
Well, there's two standards under federal law. If it's a preventative detention case, there's heightened standards in terms of what has to be found and written orders and all that sort of stuff, procedural requirements. But in the typical setting of bail, it's discretionary, and typically those are entered orally, on a court record and then can be reduced to writing. But yeah, they do make findings.
There are forms and they need a finding, because if someone is just blanketly, bail is set at $1 million, there's no finding, he's entitled to a writ to say, Judge, you never formed any basis for your opinion. It's a constitutional right to bail. If we're going to take that right away, we need to have reasonable standards so that they don't be denied bail.
Yes, and certainly if the judge doesn't give a discretion, that's a reason for the decision. That's an abuse of discretion.
And it doesn't matter how good our system is, there's going to be some people on bail that may violate other crimes.
As one judge told me, there's no perfect bail decision.
Well, it's just as, with guns. We have a constitutional right to carry a gun and have guns. We agree that some people, though, abuse that. That doesn't mean we take the right away from everybody for guns, do we?
That's right, we don't.
So bail itself is a constitutional right, and we need parameters before we deny it. And isn't that what the Supreme Court tried to do here?
In my opinion, I think they created a presumption in favor of one type of release versus the others, and that's the problem. It's just leave everything on a level playing field, and we're all for, let's make a record and have a hearing and have a robust hearing as to why bail is set the way it is, and have robust appeal rights.
Further questions for the witness? Chairman DeGroot.
To inquire the witness, please. Thank you for being here, Mr. Clayton. I appreciate it. You sounded earlier like you're familiar with laws in other states regarding bail.
Yes, sir.
Correct. You heard earlier the question by by Representative Tolson Reich regarding the New York situation. I'm not familiar with New York's laws. Are our laws comparable to what they have going on in New York?
Yes and no. I mean, the reality in Missouri is that you have preventative detention. And your preventative detention provision, which I think is probably facially unconstitutional, but I won't get into that, says that anybody in Missouri who, quote, poses a danger can be detained without bail. That's expansive. New York's preventative detention statute is they don't have one, which means that when you say there's no bail, there's no mechanism for somebody to stay in jail, right? So the issue of New York versus Missouri is not direct. However, the restriction of judicial discretion is precisely what happened in New York, is to say that judges simply cannot do bail in these cases. Although I would point out that this law does allow greater latitude and discretions than New York laws. So it's the same theme, but I think the New York situation is much more dire because of the lack of detention.
Dumb this down for me. Are we subject to the same situation in Missouri that they're having in New York, as cited by Representative Tolson Reich?
Yes, but not as bad.
All right, that's what I need to know. Thank you.
Thank you, Representative Mitten.
So, if I just heard your testimony correctly, you said, well, we need to have a discussion. You know, there needs to be a discussion about these factors. And I come back to the rule lists the factors. Our form in the area where I practice lists the factors. Where is the lapse and robust discussion on each individual case?
Well, maybe I misspoke, but my point is there's a presumption against the use of monetary bail and the presumption in favor of the 16 other conditions in the statute. And to make findings against and to put up actual proof to overcome the presumption, I think, is a change that was not in the old rules. And I think in practice what we've seen is that perhaps judges in St. Louis don't think that their discretion is as restricted as it is, but in other areas that we've seen in talking to prosecutors that judges think their hands are tied. So, I'm not a Missouri lawyer, so I can't tell you specifically, but in other states that's what we've seen, and this certainly smacks of that we're restricting the discretion of judges.
Okay, and I just again want to say that you're with the American Bail Bonds?
The American Bail Coalition.
And that's, bail bondsmen make profit off of bail bonds?
Yes.
Okay, thank you. Thank you, Mr. Chair.
You got it.
Further questions for the witness, Representative Elbrock.
Thank you, Mr. Chair. I'm sorry, and I'm asking you this because you sounded like you knew a lot about the law, and it escapes me right now. I do this kind of law, and I forgot. Do we know what the standard of proof is? Like, what's the burden on the prosecutor to demonstrate to a judge that the person should not be given a signature bond? In other words, to be either denied bond or have a cash bond. What's the standard?
Well, it's certainly not a reasonable doubt, and I can't recall that the Supreme Court has tinkered with this as well in the rule, discussing the applicability of the rules of evidence, and I'll have to go back and read it.
Is it probable cause or?
No. And I don't think there is an evidentiary standard actually in there, but I think, as I recall, a preponderance is applied in these cases. But I'd have to, I'm just shooting off the cuff here. I don't know for sure.
Okay, thank you. If anybody else that's going to come and testify might know, I'm interested to know that answer, and thank you.
Thank you very much. Representative Hicks.
Thank you for being here today, sir. I'm just curious, but how many other states do you work in on issues similar to this, the bail issue?
I don't know. Maybe 35 I've been to, maybe. I don't know.
Excellent. Thank you. I was just wondering because you do seem to be so knowledgeable in the industry. I was just curious. It sounds like you've been doing this a while.
Yeah, I've been doing it a while.
Thank you.
Further questions for the witness, Representative Trent.
Thank you to inquire. And this might have been stated earlier, and I just missed it, but there are more people being let out without bail now after this rule has gone in place, correct?
I think so. I don't think that prosecutors are filing heightened detention motions, so I think the result has been more releases on recognizance.
Increased releases. And you stated earlier that you believe that this limits judicial discretion in deciding bail. So in other words, to translate that, there are more people being released out on the streets that judges, had they been able to exercise their discretion, would have kept in jail or required a cash bail.
I believe that's correct, yes.
Well, I find that to be very troubling. Thank you. Thank you, Mr. Chairman.
Further questions for the witness, Representative Sauls.
Yes, thank you to inquire. Thank you. Just out of curiosity, you're talking. Are you familiar with caseload, increasing cases, and things of that nature?
that criminal cases are increasing, or
Yes.
Within the state of Missouri? I'm not familiar with case processing statistics. in
Because
Missouri.
the question I have is that with regard to that issue, for example, Jackson County has an 800-bed jail, which is not very much for that size of a county. I think that this has been something that has consistently happened in that people are being released because of the incident, because of that. If you have 800 beds, you only have a certain amount of space. You subject people to guards to injury, the city to lawsuits. Just in general, you just don't have the room for individuals. So I don't know if that comes into play as well. I'm curious about it increasing, because if that's the case, then the natural answer to this question is you're trying to release more people out because the jail is full. So I'm just curious. I don't know if anybody else has the answer to that, but it is something that I think could be an answer to the question.
Well, I would say that jail overcrowding drives almost all conversations, not all, but a lot of conversations on bail reform. It's important to look at the impact of bail reforms on jail populations. What I will say is that there's been no effort to figure that out here. You know, Pew Charitable Trust in Michigan donated $1 million to study the situation, and they discovered that 83% of jail costs are driven by 17% of defendants. So you've got people staying over 30 days. That's what's driving this. And so the opportunity for reform on the cost side is small. But we don't know that unless we pull the data. But as you said, jail overcrowding issues are critical on this and are our main driver for bail reform.
Do you think that could be a reason for people being released? I mean, do you see that as perhaps an answer to this? Why Representative Hill indicated that 30% of people being released, is that, I mean, are we having an increase that fluctuates more than 15%? I mean, could that be a part of this?
You know, I don't know the statistics for sure. What we've heard is that when the rule went into effect, we had a significant amount of releases, and that over time, as defendants fail, judges begin to hammer them. But really, I don't think it's settled out. But you do highlight a point. Let's get some data on this, figure out what's going on.
Okay, thank you.
Further questions, Representative Roberts.
Thank you, Mr. Chair. Thank you for being here today. There was some talk as far as a greater release of people, but my understanding, and I'm just looking at an article recently, Kansas City Star, where you have the Bond Litigation Counsel, Matthew Mueller, saying that the rule changes had very little effect. So do we have any hard numbers?
I don't think we do. And as I said, I mean, it's all anecdotal that it was sort of one procedure when we started, and then now maybe it's something else.
Well, I think that's a great point. I mean, I think these cases, it sounds like they're anecdotal. There's this huge outpouring of saying, well, they're making these rules, but we don't have any numbers backing up the claims that there's, this catch and release, that there are all these people out in the population. It could be that none of that's actually happened, that our numbers are the same and the rule change hasn't made a difference at all, right?
I don't think that's the case, but certainly I don't have any numbers to contradict that.
Okay, so you don't think that's the case, but you don't have any
That's
evidence
right.
to contradict it.
Yep, I agree, but I don't think there's any evidence on the other side.
All right, so before we legislatively try to make these changes, shouldn't we see what the data shows? I mean, what if this is not affecting it in the way that you think it is?
Well, I think the better position would be to say, let's start over, to say that the Supreme Court didn't have the data to make the changes that they thought were necessary, which they didn't. There is no report. There is no data pulled. So I think the argument is for both. If there was no data to do the rules, there's no reason to keep them.
Well, would you agree that the kind of current system of mass incarceration isn't working? Doesn't make Missouri a safer place to live?
I think America does over-incarcerate people. I think that there's really no doubt about that. And what to do about it, I think, is where we failed.
All right. And do you think that it is possible that this rule change could fix that problem of mass incarceration? Is it possible?
I don't think this rule change is going to fix mass incarceration. If anything, I think over time it'll contribute to mass incarceration.
Okay.
Because the public's going to get angry and prosecutors are going to start seeking detention after so long. And we've seen that in New Jersey.
All right. Well, thank you for the inquiry.
You bet.
Further questions for the witness, Representative Mackey.
Thank you, Mr. Chair. So far, the conversation is centered around folks who are granted bail, not granted bail, leave, don't show up. What about the issue of electronic monitoring and electronic bail practices? How does that fit in, particularly for the bill sponsor, but for you as well, just in terms of your experience? Is that a direction that we've seen head in? Has that conversation headed in a productive direction in our state or in other states?
Well, I would say it needs to happen. And a judge held the New York law unconstitutional under the following analysis, which is that non-monetary conditions of bail can be more restrictive than bail. And how can that be? Well, if a third party posts a bail, like for my son, I post my son's bail, and he gets out, I'm guaranteeing his appearance, and the judge doesn't do an ankle monitor. Well, if the judge decides instead they're going to put my son on house arrest, ankle monitors, all that stuff, that could be more restrictive than bail. So I'd say there's an emerging case law to say that, do we really want to hammer these people with all the technology, as an alternative? Years ago, I told the legislator, don't trade a night or two in jail for an electronic ball and chain for a generation, right? And you don't want to take the problems in the bail system that you think are bad and replace them with something worse. And that's what we're seeing. And one public defender told me that if you want to understand bail reform, follow the money. And we've seen that use of electronic monitors, kickbacks to states, taking money from offender fees.
I mean, they pay for it themselves.
They
so
pay
they're
for
still
their
out,
own
yeah.
dragnet, right?
Sure.
And that's profitable, and localities have an incentive to do it. And in fact, one director of the Pretrial Justice Institute said that at a conference, the vendors were walking around saying all this stuff's free. You might as well hammer defendants with it because it's free and they pay for it. Well, that's not the right answer either, I wouldn't think.
Okay, thank you.
All right, very good. Thank you very much, sir. Representative, I'm going to actually
Thank you.
I want to compare and contrast testimony, so I'm going to call a witness in opposition to the bill up next. Witness in opposition. House Bill 1937.
Mr. Chairman, members of the committee, Brian Byrne-Skinner, here on behalf of the Missouri Association of Criminal Defense Lawyers. We were not able to secure our witness, but he did provide extensive written testimony, which should be included in the Orioles pack. He did go kind of line by line and talk about some of the concerns. I'm not sure that I would be doing him justice if I highlighted one versus the other, but I think he did a really good job of detailing some of the changes that the bill proposes to do versus the process that he and others went through for nearly months long, reviewing these rules and trying to establish something that strikes at fairness and getting folks opportunities, particularly if they don't have financial means, to get some sort of bail that allows them to continue to be productive members of society while their cases are pending.
Okay. This will definitely be read. Questions for this witness? Seeing none, thank you very much. Representative, call your next key witness in favor.
Thank you, Mr. Chairman. I would request that one of the sheriffs come up. Maybe my sheriff, Sheriff Lewis. That would be great.
Come on up, Sheriff. Thanks for being here. Please don't forget to fill out a witness form and proceed when you are ready.
Thank you, Mr. Chairman, members of the committee. My name's Scott Lewis. I'm the Sheriff of St. Charles County. And what I would like to just mention is Representative Hill's already talked about what the issues are for us, and that is a 30% increase in the failures to appear. There's no incentive to show up for court. So, we're spending our manpower and our transportation costs driving around the state and driving around the United States, bringing these people back to St. Charles County, and quite frankly, the transportation costs you guys are reimbursing us for. So it's a cost you're paying. I don't know about the process that the judges go through, but at least in St. Charles County, I feel like the judges feel like their hands are tied, and if it's not for one of those, they're a threat to the community, a threat to the victim, a flight risk. If it's not one of those things, they're letting them go without any bail. And then they don't show up to court, and we have to go get them.
Thank you, Sheriff. Thanks so much for being here. We appreciate what you do for us. Representative Hicks.
Aha, finally got you on the stand, Mr. Sheriff. No, thank you for coming today. As a representative of St. Charles County, thank you very much for taking the time to come up here today. My question, I was going to ask the representative on the sponsor of the bill here, but it's more to you, I guess, is what it's going to be for. you're talking about time and money and things like how much time and money are you wasting with officers that are trained to be police officers being bail bonds agents going after someone that skipped on bail?
It's a significant amount. It's a 30% increase since last July.
And so are we having to go out of state for things like this as well?
Yes, sir.
Okay. Thank you very much. I've heard enough on this one. Thank you.
Further questions for the sheriff, Representative Shore?
Brief inquiry.
Proceed.
Thank you, Sheriff, for coming. I believe you. It should be noted that you went to high school in the best district here in our good state. But what I wanted to focus on is one question with your expertise in our courts. Have you seen an increase in the amount of offenders, let's say, reoffending or committing further crimes before they are tried under this new rule?
In St. Charles County, we don't have any of the dramatic stories that somebody mentioned earlier about New York or the one in Kansas City. We don't have any of those types, but I can tell you for sure that those people are reoffending while they're out without bail.
So previous to July, do you think that they're reoffending more while they're out or less? Just to kind of get a sense of where you guys are seeing increases in crime.
I don't have that exact number, but I can tell you that we see some repeat customers. They go into Victoria's Secrets and grab an armload of merchandise, and they're out down the street, and they get released without bail, and we'll see the same person again.
Well, I know when I look at, from a citizen's perspective, and we watch the news every night since July, it seems that we've seen a rash of these where these people should have been locked up, so to speak, or under strict confinement, strict whatever it may be, but these new rules are letting them reoffend. So that's where I'm trying to get a sense. I've seen the big stories occurring, one in the Kansas City area, but again, just thank you for being here.
Thank you, sir.
Further questions for the sheriff, Representative Mackey?
Thank you, Mr. Chair. I think we all understand the purpose. One of the purposes of bail is to ensure that folks show up back in court. And I think that 30% increase is an issue that we ought to be addressing. But I'm also wondering if you see the inherent inequity or inequality. We can't guess who's going to show. We don't trust anybody to show up. That's why we charge them bail. Do you see any inherent problem with somebody who's got the money to paying, and the person who doesn't have the money being charged to sit in jail? Do you see any inherent inequity in that?
I do. And what I want to see is our elected judges, to have that discretion, they're the ones that, are seeing these cases, and they should be the ones to, make that decision.
And I think they are. I mean, I think they're exercising that, and I think they're doing their best. And I think by trying to address some of the inequities, I think some of the unintended consequences of that is that we see an increase in people that failure to appear. I'm wondering if this is the fix to that, or if there are other fixes to that. Is my question. I don't see necessarily how this is the fix to that.
If I can address that, this is a do-over. Like, this is the most discussion we've had on this issue because we didn't have a bill referred, and the Supreme Court made this law. We did not. So this is where our constituents get their voice. So do I think this is the way? This is the way because it puts us back to where we were before they implemented it, and it allows us to have the discussion to implement this law. So I'm with you. Just because you don't have money doesn't mean you should sit in jail longer because, you know what I mean?
Right. I mean, that's what we're trying to solve here.
Yeah, but we didn't get a voice. And you also bring up another good point is, like, there is a cost to this, a financial cost to the state, to the taxpayer, and we didn't even get to see a fiscal note. Why? Again, because we didn't get to make law.
I got that point. I'm not going to rebut it right now. Thank you.
Representative, I can't let you cut back in on your bill next time, okay? All right, so just hang tight till you close at the end, please. Representative V, that's right.
A 30% non-apparent is a significant amount, and I find that concerning. But what I find is this present bill doesn't prevent judges from putting all the restrictions they need for bail. And so maybe it's an issue is that the judges aren't following the rules close enough because they can put them on monitors, they can make them stay in jail, they can do everything. There's nothing changes any of that. And so I think maybe it's more of an issue that some of the judges are overusing their discretion by allowing too many people out on bail without cash. I mean, if they think they're not going to appear, that's one of the factors that they can consider in saying you need a bond or you don't go. If they think that you are a threat to your witnesses, which is an important thing, you don't let them out. All of the pre-trial stuff, and you also realize that some of your people who are in your jail or out on bond, they have jobs, correct? And when you agree that of those people to go through your jail, probably over 90% get probation if they plead guilty.
I don't run the jail in St. Charles County. That's a separate agency, but I would suspect you're pretty close.
But one of the reasons from society, if someone's arrested, we kind of like them back so they keep their jobs, so they can pay their child support and pay their house payment and don't get behind on everything else, so they make successful probation.
Correct.
But with that, there's some risk. There's going to be some people, I don't care what we do, you put them on bail, they're going to commit another crime.
Correct.
No further questions.
All right, last line of questioning for the sheriff, Chairman DeGroat. Very good. Sheriff, thank you so much for being here. I appreciate it. At this point, we are going to move much quicker through the witnesses. At this point, witnesses are only going to get 30 seconds, and then I'll open it up for questions. Next witness in favor.
Mr. Chairman, could I have Sheriff Millsap? I think he can give us a good 30 seconds.
Good.
Thank you for the committee, and I'll try to take my 30 seconds very quickly.
Thank you.
County has issued 1,115 warrants since July 1st. 53% of those have been failure to appear. There's been 249 probation warrants. Many of those are failure to appear, though they're categorized differently. 690 people have failed to appear on their warrants after they've been issued. I have 15 deputies in operations. So I have 15 deputies who are now basically doing the job of a bail bondsman, trying to locate 690 people that have failed to appear to court. We answer 23,000 calls for service in Laclede County. I don't have the operational manpower to go down chasing people down that should have probably stayed in jail or at least had a bond in which a bail bondsman would have gone and picked them up. I only ask the committee to look at, put this back in the hands of the local judges. Thank you.
All right, Sheriff, real quick, what's your name for the record?
David Millsap.
Very good. And you're the sheriff of Laclede County, I'm assuming?
Laclede County, yes.
Very good. Tell me, you said in Laclede County, how many warrants were issued?
We issued, since July 1st, 1,152 warrants.
Okay. And what was your next stat?
And 53% of those have failed to appear.
Okay. And what was that stat, July of 2018?
I don't know what the stat was in July of 18. I can get that or try to get that.
At your best estimate, what % were your failure to appears prior to July 1st?
I would hate to try to venture a guess, but far less than 53%.
Okay. Questions for the sheriff? Representative Elbrock.
Sheriff, thank you for being here. And I appreciate you engaging us in this conversation because I do think it's important that we have it and everything we can do to help the administration of justice here. But you said you felt like you wanted to put the decision back in the hands of your local judges. And is that the sense that you're getting, is that your local judge there, I presume Laclede County is elected, is that correct?
That's correct.
And you get the impression that your local judge feels as though the decision
I have a lot of conversation with the two associate circuit judges, and I feel that they have expressed to me they feel their hands are tied in being able to make their own decisions regarding what an appropriate bond would be if bond would be set. That they feel like that they have been led down the path that they are to release people and not ask for a cash bond.
Thank you. That's very enlightening. That testimony right there, I think, hits it right on the head. Thank you.
Further questions for the sheriff? Seeing none, thank you so much for being here. Next witness in favor.
Thank you, Mr. Chairman. I'd like to have Sheriff Bonham up.
Okay.
Good afternoon. First of all, thank you for hearing us out. There's many of the sheriffs, I don't worry redundant in the testimony, but we've already seen the same thing. We've arrested one in the morning and then arrested him later on in the afternoon. Same offense. And so we're seeing that. He had a bond, he would have been there and stayed in jail. But we're not seeing, my failure peers are similar, about 32% up. Crime is up about 32.5 overall. So we're seeing the same as results. My judge feels the same way. Prosecutor feels the same way. We want to do the right thing for our public, as I'm sure you do too.
Very good. Sheriff, thanks so much for being here. You're sheriff of what again?
Osage County, right over the river.
And your name again, sir?
We're the drive-through county.
Drive-through
Instead
county.
of the flyover.
And your name again, sir?
Mike Bonham, B-O-N-H-A-M.
Thank you so much. So one of the things that Representative Elbrock brought up that was very interesting, seems to be a theme we're hearing, is tell me about your discussions with your judges. How do they feel with regard to these new changes?
We just had a new appointed judge, and she's still learning, but our previous associate and also our circuit judge feel that they're somewhat restrictive in giving bonds now. And my criteria is even narrower, that either that they've had failure to appear in the past or they're a threat to the community.
Okay.
And we have to put that in our PC, which is not a problem, but
Okay. Thank you very much. Questions for the sheriff? Representative Roberts.
To inquire briefly.
Proceed.
Thank you. Thank you, Sheriff, for being here today. You mentioned, you'd arrest them in the morning and they'd be picked up again later that afternoon. What type of cases are those typically where people are reoffending?
both of those were drug cases, the same thing.
Okay, so like a drug addict kind of thing?
Absolutely.
All right. Is that kind of the majority drug possession?
We've seen burglaries. We've had one that was arrested on burglary on Monday, and we re-arrested him for another burglary on Wednesday. So,
All right. Thank you, sir.
Thank you very much. Further questions for the sheriff or Chairman DeGroot?
To inquire of the witness chair. Thank you. Well, it's really a statement rather than an inquiry, but on behalf of the whole committee, and most of us are attorneys or are in court quite a bit, the sheriffs typically provide security, and I just want to tell you thank you. We all appreciate it. I don't mean to be pandering, and I really didn't want to say this to appear that way, but it really means a lot to us, so thank you very much.
thank you. May I add one thing?
Yes,
That's okay. Just re-announced election, that's not the point, but there was a comment in the thread, exactly that. Sheriff, you need to keep these people in jail, like it was my fault. I don't have any control over that. And so a lot of it comes, the anger from the public comes directed towards the sheriffs unjustly. And the legislating, I'm sorry, but I said, please call your legislator and let them know.
No, you should encourage them to call their legislators. We support that very much.
Yep.
Further questions for the sheriff? Seeing none, thank you so much for being here. Next witness in favor.
Mr. Chairman, I think we have a few more sheriffs that'd like to say their piece.
Absolutely, please.
If they can just randomly come up, that'd be great.
Well, come on up, sir. If just for the record, you can go on the record in support of everything you've heard from the sheriffs, if you don't mind.
Hello, I'm the sheriff for Clark County. I can tell you our 3 or 4 Thursdays ago is when we have our associate court. We had 40 warrants issued on Thursday. Since July, we're averaging, my judge and the clerk have both told me, averaging 25 every Thursday, about 25 warrants a week. So that's up quite a bit. And it even goes into, we did a search warrant a block from the middle school because we found stuff. During the search warrant, we find a big bag of meth, firearms, guns, shotguns, brass knuckles, nunchucks, a crossbow. Felons cannot possess any of this stuff. On the way out the door, he tells his girlfriend, have somebody fix the door that they broke coming in. You need to do all these things. I'm not going to be home for a while. He was home 25 minutes later. That's all I have. No, he did not have to bond out. And he told me on the way to the sheriff's office there was no way he was going to be able to bond out.
Very good. Thank you, Sheriff, for being here. Questions for the sheriff? Very briefly, Representative Elbrock.
You're of the opinion, Sheriff, thank you for being here, by the way. I know Clark County's a long ways away, so thank you for the drive. You're of the opinion that if the defendants in these cases had a little bit of skin in the game, they'd be encouraged to get back. In other words, if they had to post some kind of a cash bond, they'd be encouraged to come back.
Absolutely. That is, it makes me sick that a block from a school, he can have a bag of meth, crystal meth, that still looks like ice chunks. Firearms, he's been in prison. And he did not have to bond out. That's nuts. That is nuts. And I apologize, guys. That's crazy.
That's okay.
We're all concerned.
I'll
Thank
come
you for
down
being
here
here.
every day for a week to say this. It's nuts.
Thank you so much, Sheriff. Very briefly, Representative Mitten.
I just want to say that I agree with you, as I think that everybody on this panel does. That is nuts. And I think, I mean, my opinion when I walked into this hearing, and it hasn't changed, is that this is an issue about educating judges. Because there was no reason for, I agree with you completely, there was no reason for that person, somebody that's already been in prison and was caught with all of that stuff. That does not make sense. That is not what the rule says. And that is an issue of educating the folks that are making these decisions. And I understand that that's not your call, but if you read it, that's not what the rule says.
Can I add one
Yeah,
more thing?
please.
I think it's sad also that we're arresting people for meth that's got serious problems that are out violating because of the meth and stuff that's causing other crimes out there. Were told last week by our prosecutor not to even file for a warrant for somebody that does meth, that we arrest for meth. It's a court date and pretty much a site, book them in, book them out, and it's a court date for somebody we're arresting for meth. And I can tell you almost every other sheriff here will tell you that. If it's drugs, it's a court date, period. We're being told unless it's a violent crime and they have a history of failure to pierce, they're out. And that's sad.
Okay.
That's all I have.
Thank you. Thank you so much. Sheriff, thank you. Even though you said you didn't have a lot to add, you had plenty of different stuff to add.
Invited me up anyway.
Yes, I did. I'm glad you came up. Thank you so much for being here.
Mr. Chairman, did you get his name for the record? It's Sheriff
Yeah.
Webster.
And you have a witness form? Very good. Thank you.
And I think there might be one more sheriff, and then we can go for those who want to testify on the record.
Thank you, Chairman. Thank you, Committee. I'm Sheriff Wayne Wynn from Scotland County, Missouri, a long ways away. I just want to add that we face similar problems at Sheriff Webster. We border with Sheriff Webster. We recently had a guy that set fire to a house and was arrested by a deputy, brought to jail. We're a small jail. We only have him. He was the only inmate in the jail at the time. He literally destroyed the jail within 15 minutes before jailers could get back to him, and ripped out all the water lines, destroyed the television, everything he could get a hold of he destroyed. He was out the next day because it did not meet violent crime. So that's all I have to say.
Okay. Thank you, Sheriff, very much for being here. Representative Mitten.
I'm going to real quickly follow up with this is that, again, one of the factors on this form is the defendant's character and mental condition. And this comes verbatim from the Supreme Court rule. This is not about the Supreme Court rule. That defendant's character and mental condition, given what you just testified to, is exactly the situation where you would say, no, that character and mental condition has been shown by virtue of what happened in that jail cell to say that we are a cash bond or some other monetary situation is required to secure the appearance or secure the safety of the community or others. So I just want to, that's what the law says. That's what the rule says. Thank you, Mr. Chair. Thank you.
Yeah, no problem. And thank you, Sheriff, for being here. But clearly to me, after hearing from all the sheriffs, there's a major disconnect. I don't know what it is. I don't know exactly what's going on, but we're going to get to the bottom of it because it's not some coincidence that several sheriffs have come up here and expressed the same concern over and over and over again. So while I'm certainly not looking for any kind of legal conclusion from you, you're not a lawyer, I certainly can see a law enforcement conclusion from every one of you. So I want you to know that you sheriffs being here means a lot to us, that we see that there is some disconnect. We're going to get down to the bottom of it, and we want to fix these problems that we see. So thank you so much, Sheriff, for being here.
Thank you.
Any other sheriffs? Any other witnesses in favor of House Bill 1937?
Thank you for allowing me to speak. I'm not used to this, but I am a bondsman, and not only do we feel like our resources that the taxpayer yourself pay for, the officers can't keep up with what's going on. Myself, I have a system to where each defendant, if I bond them out, they have to check in with me once a week. If they do not check in, I will look for them. They have to appear in court. If they do not appear in court, I have to fine them. They have to, of course, there is money, but if they don't do what they're supposed to do, we specify that if they are, they are given no contact, say it's a domestic, they're explained to them, you can have no contact. But we go further to explain to them that no contact means if you see them on the street, you go to the other side. You do not send a friend to text. You do not send any of that because that's contact. That gets you right back in jail. But I want to talk to you about the human aspect.
Very, very briefly, please.
Please, yes, sir. We help people in that we care. We care, and I would like to give you an example. Molly was one of my clients. Molly has turned her life around and is doing amazing things. And as Molly would testify to you, that it's because we cared.
Very good. Very good. Thank you so much. And what did you say your name was?
Janet Garms.
Very good. Thank you so much for being here. Questions for Ms. Barnes? Seeing none, thank you so much. That's very helpful. Next witness in favor.
Mr. Chairman, members of the committee, Mark Bruns on behalf of the Missouri Fraternal Order Police, the Kansas City Fraternal Order Police, and the St. Louis Police Officers Association. We just want to go on record in support of the bill.
Thank you very much, sir. Questions for the witness? Seeing none. Next witness in favor.
Hi, my name is Molly Lake, and if it wasn't for Janet and Ray Garms, I would probably still be in and out of county jail. I did anything from CNI driving to peace disturbance to helping my ex get out of booking or helping him sneak stuff into jail was the things I was caught doing, and I made a promise and gave Janet and Ray my word that I will show up to court and I would do as I say on any rules after that. If you guys were to go away with it, it's easier to get out of jail without a bail bondsman than it is. So if a criminal has the money, say a drug dealer, it's easier for him to get out because he has the money right then and there. He can just throw it to you and then be back out in the streets within however much time.
Okay. Thank you very much for
Thank
that.
you,
That's
guys.
very, very helpful. I appreciate you coming up here. Questions for the witness? Seeing none. Next witness in favor.
Mr. Chairman, members of the committee, for the record, I'm James Harris, registered lobbyist for the Missouri Alliance for Professional Bail Bond Agents, the Missouri Bail Association. Have some written testimony, just go on the record in support of House Bill 1937.
Thank you so much. Questions for the witness? Seeing none. Thank you, sir. Next witness in favor. Seeing none. Any other witnesses in opposition?
Good afternoon. My name is Monica Delvalar. I am the Legislative Associate with the American Civil Liberties Union of Missouri. We would like to express our opposition to House Bill 1937. A lot of our concerns with the removal of monetary conditions as the primary condition to ensure court appearances have been addressed, so I will move on to our second point, you're fine. This bill looks to eliminate the need to have those arrested seen before a judge within 48 hours. The rule used to say that the bill currently says that they will be seen before a judge within 48 hours, excluding weekends and holidays, after being confined by the Department of Corrections. The change would be to as soon as practicable. There is no measurable duration attached to that, and that could be hours, days, weeks even. We have had some discussions with some public defenders who have said sometimes it's just whenever they can be added to a docket, and that, again, has no measurable duration behind it. So we feel as though this bill swings the state back in the wrong direction when it comes to pre-trial detention and criminal justice reform, and we urge that you vote against it. I'm open to any questions, and thank you for your time.
Thank you so much for being here. Questions for the witness, Representative Elbrock?
Thank you for being here. I appreciate your testimony today. Do you have any credible evidence or any examples where an individual was held in the state of Missouri for several weeks or months without having any kind of bond hearing at all?
No, sir.
You don't. So we're just basically.
Taking my word like we took the word of the people before me.
I do this for a living.
I got you.
And the previous standard was 48 hours excluding weekends and holidays, which was usually pretty. And in the jurisdictions I practiced in, they would come in sometimes over the weekends just to assign a bond, or a warrant would go out with a bond already on it, stuff like that. But like, it's not. I guess what I'm struggling with is couching this in terms of like this bill is going to do something so overly dramatic as to deny people a bond hearing for several weeks. I mean, that's not realistic, is it?
Is several days potentially realistic? And
Several days is what they get now, 2 days. And then if it's a holiday, what we had before January 1st, it could have been 4 or 5 days at most. Like if it comes over a holiday and Christmas Day is a Monday, now you're looking at having a bond hearing on Tuesday. If you got picked up on a Friday night, you got 4 days in.
And is that particularly problematic?
I mean, in
keep
some
it
cases,
at 48,
in some
excluding
cases
weekends and
it's not,
holidays?
because if I've got a client on a driving on suspended and he's on a 10-year denial and he's been in for 4 days, I'll walk right up to the judge and say, guilty, Your Honor, request time served, and they'll let him go that day. Like, 4 days ain't the end of the world. So I'm just saying that, like, when we talk about these things, it's important to keep a good perspective because it helps the conversation when people are straightforward, but that we don't exaggerate sometimes too. And I'm not trying to be rude to you or anything, but Missouri's judges aren't holding people for several weeks without a bond hearing.
We feel as though this extended detention or possibility of extended detention affects defendants' right to due process in a speedy trial. And extending it beyond a measure that has no duration attached to it could potentially lead to issues that further create unconstitutionality.
Okay. Thank you for your testimony.
Further questions for the witness, Chairman DeGroot.
Thank you to inquire the witness. That's been my experience too. I don't know where you're getting these examples from, but I practice primarily in St. Louis City and St. Louis County. I've never seen a bond hearing take more than 2 or 3 days. Are you talking about outstate judges? I wish a member of the judiciary was here to confirm or deny what you're saying, because I kind of think you're taking pot shots at them without having them present.
I would not do so, and I'm not representing the judicial branch.
I didn't say you were. I think you're taking pot shots at them. I think you're saying that they're not doing their jobs. Every judge that I've ever had to deal with on this issue has bent over backwards to come in, and sometimes the answer is no, and I don't like their answer, but they come in and they do it. They have their bond hearing.
We would like that to remain within that 48-hour confinement period.
And why do you think that won't happen anymore?
There is nothing that says that it has to happen anymore.
I don't see that is going to be a huge problem, at least in the areas I practice. I wish you had more specific evidence that I could point to and touch and feel, because I just don't think that's going to be the issue that is going to be a problem for us.
Understood. Should I be able to receive that information? I would love to give that to you.
I would love to
all
see it.
members of
Thank you.
the committee. Thank you.
Further questions for the witness? Seeing none. As a reminder, if all witnesses can please fill out a witness form. Make sure you fill out that witness form. Next, witness in opposition. Seeing none. Any other witnesses to testify for informational purposes only? Seconds, sir. Please remember to fill out a witness form and proceed when you are ready.
Chairman Gregory, members of the committee, my name is Steve Sokoloff from General Counsel of the Missouri Association of Prosecuting Attorneys. We're testifying for information purposes. We have no opposition to this bill. We would suggest a couple of minor technical changes, most particularly in the provisions of bear with me for just a moment here. In the provisions on page 8 of the bill, line 55, in the old provisions, it required that the victim of an offense be given notice of an opportunity to be heard at any bond hearing. And we think that should remain or be included in the bill, and that it's important to make sure those rights are considered and protected. Otherwise, there are a couple of small language corrections that I would just address with Representative Hill. But beyond that, we have no opposition to the bill. I would point out that in regard to the time periods, that even prior to the new Supreme Court rules, bond hearings did not take 2, 3, 4 weeks to occur.
Okay. Thank you. And, sir, if you don't mind those recommended changes, can you get those to me in writing?
I will.
Make sure they get dispersed to the
Yes, sir.
committee. Very good. Questions, very brief questions. Representative Elbrock.
Would the Prosecuting Attorneys Association, and you don't have to have the answer right now, I know because we're just putting the question to you, object to reincorporating the old language of 48 hours, excluding weekends and holidays for a bond hearing? Is that something that you would have much of an objection to, just to assuage the fears of people?
The only aspect of that I think that can be problematic is notification, and getting a victim witness to attend within that time period sometimes can be difficult.
But it was the old rule, correct?
Well, it was the current rule. The old rule did not require that.
Because the normal notice period is 10 days, correct?
Well, it depends is the answer. Obviously, the first appearance or first consideration and an appearance before the court, as under the rule as it exists now, is the 48 hours.
Right.
Prior to that, there wasn't any specified period of time. In other words, if somebody was issued, if a warrant was issued, then it either needed to state no bond, or it needed to have a bond set and on the warrant. Then, as the rule now, as it exists currently, provides that initial hearing before a court has to be conducted within 48 hours.
Thank you.
Further questions for the witness, Representative Sauls.
To inquire. Thank you. I will try to be brief. There's a little bit of chatter up here, and I think that we've kind of come to a conclusion that, at least some of us have come to a conclusion that the problem is not so much the current rule, but the implementation of it. Like, from what I can gather, the current rule outlines various factors that come into play for this exact situation, and somehow there's a disconnect. Would you tend to agree with that, or what is your assessment of that?
I would suggest that I think there are a lot of judges who seem to misunderstand what the actual factors that are supposed to be considered, and that there really isn't any change in the law, or wasn't any change in the law, other than the fact that the judge had to make findings of fact with regard to his or her reasons for setting a particular bond or denying bond and remanding the defendant. But so far as what kinds of considerations the court gave to setting a bond or declining a bond, those haven't changed, I think, under the rule, under the current rule.
Sure. So, and that's kind of what I'm seeing here. I mean, you can ultimately have a bond based on these factors the same as you could before. You just have to give a reason for it.
Exactly. Yes, I think that's the case, and I think there seems to be an educational disconnect that the judges are not understanding that it really hadn't changed that much. I think they feel like, and I'm projecting here because I'm not a judge, right. But it seems like they feel that this changed what their considerations are supposed to be insofar as setting a bond. The only thing I think that is changed under the terms of the current rule is that ability to pay has to be considered in terms of either the conditions that are set for a bond, that is, if it requires electronic monitoring, ordering a defendant to pay for that sort of thing, or that in the setting of a cash bond, that those things really have to be considered more significantly than they did before.
And perhaps my last question on this is, or perhaps comment. Some of these, these rules went into effect, I believe twice. There was one or two parts to this. One was in August, and one was January. Is that?
That is correct.
Two-part question.
Yes,
sorry.
no, that is correct.
Okay, thank you. That being said, this is all still very new, very early. It would seem as though if there is a disconnect with judges interpreting this rule, this would be the time that that's happening. Is that fair to say?
Yes, sir.
Okay, so do you think that the current rule serves the same purpose?
I'm not sure if I follow you, sir.
Do you think that the current rules would serve the same purpose as this, at least with the intent of taking these factors into consideration? Would you agree with that?
When you say the current rule, you're talking about the one that's proposed here or the one that is in effect?
The one that's in effect now. Would you agree that the same factors can be taken into
I think
consideration?
basically the decision process is very similar. I don't know exactly the same, but yes, that process and the considerations are going to be significantly and substantially the same.
I appreciate that. Thank you.
Mr. Chairman, there is one other thing that I did want to mention, and that is that the only other thing that we would also ask to be reincorporated is the court's consideration of use of electronic monitoring, including GPS, which is deleted in the proposed
Okay,
in the
please
bill.
add that to your write-up. Last question for this witness. Seeing none, thank you so much for being here, sir. Any other witnesses to testify for informational purposes? Please remember to fill out a witness form and proceed when you are ready. 30 seconds.
Thank you. Good evening. Sarah Johnson here with the Public Defender System. Just wanted to address a couple of questions that were asked. Representative Ellenbrock, you asked about the standard that is required to keep a person detained. That standard is clear and convincing evidence, and that's contained in the current Supreme Court rules. Representative Mackey, you asked about a person having to post a certain type of bond. Currently, as the rules require, there is an individualized determination made upon a person's ability to pay. So a judge currently has to ask that person what kind of bail they can afford, and if they've determined that non-monetary conditions don't suffice, they can put those monetary conditions in place. I just wanted to talk a little bit about the impact on our caseloads. Currently, if an individual is released or they are able to have a summons, they can go back to their jobs, they can go back to their communities, they can continue working, and they can hire the attorney of their choosing. With this removal of the bail rules, they would potentially remain incarcerated, people who are considered not violent or flight risks, which would potentially increase our public defender caseload. So I think that is something that this committee should consider. There are people who are nonviolent who are being released under the rules, and if those people are kept detained, that will potentially increase our caseload. I also brought with me Ryan Hayner. He is a line attorney with the Public Defender's Office, and he can speak to some of the practical implications of this bail rule.
Okay. Questions for the witness? Representative Ellenbrock. Proceed.
Thank you for being here.
Thank you.
So the clear and convincing standard was, I was aware of that for denying bond altogether, so that they have to be, but the rule also cites like any, and I'm just trying to quote it off the top of my head, but it's like any combination of monetary bond, and they don't cite a standard, they just ask for the consideration of the factors. Isn't that the way the rule currently reads?
Yes, it is.
So then I could, if I was a judge, I could give somebody a cash bond if I believed that the cash bond would assure their return to the jurisdiction, and I considered all other factors, and as long as I gave a reason why I was giving a cash bond. Maybe the reason would be just to ensure that their return to the jurisdiction. Isn't that fair?
That is correct.
So it's not a clear and convincing standard to give somebody a cash bond, which might be part of the misunderstanding that some of the folks have been having across jurisdictions, is that they don't have to meet the clear and convincing standard to issue a cash bond, just to issue the no bond.
Correct. That's correct.
Okay. Thank you.
Any other questions? My only question is this: so you're suggesting that if these defendants can't afford bond, they should be released, go back to work, so that they can then afford to hire an attorney? Help me understand that.
Sure. So, Representative, many of the individuals who are going to be released on either a summons or released through the current court rule on a recognizance or a combination of monetary and non-monetary conditions are then going to go back to their communities, and they potentially have the funds to hire an attorney of their choosing, a private attorney. So if they are kept in jail, they're going to lose those jobs. They are going to lose their homes. They are then going to be deemed indigent for the Public Defender Services, and we are going to be appointed.
While they're
as their
in
attorney.
jail, they still technically have the job by their hearing within 2 days, right? So if there's a hearing that deems that they cannot afford it, even a bond, you're telling me they get released and a couple weeks later they can all of a sudden afford to hire their own private attorney?
So In 48 hours, they're given that hearing, correct? And so are you assuming that in that 48 hours they are detained or they are released?
I'm assuming that they're being released on recog because they can't afford a bond.
Great. And then they are going to go out and hire a private attorney because they're still going to have that job. They're still going to be able to go back to their
They're
community.
still going to have that job that they couldn't afford a bond on, but they can afford a private attorney on.
The requirement of indigency is very low. We follow the federal guidelines, federal poverty guidelines, so it is a very, very low standard to determine indigence.
Further questions for the witness? Representative Sauls.
And I think to inquire. Thank you. And I think you briefly talked about this. Can you tell me how this would fiscally impact the public defender system?
Sure. So I think that if the individuals who would be released under this current rule are kept in jail, like I said to the representative, they're going to stay in jail. They're going to lose their jobs, and they're not going to be able to afford to hire private counsel. So we are going to continue those cases. We're going to be appointed on those cases. It's going to exacerbate the caseload problem, and we are going to we're going to keep coming in front of this legislature asking for continued funding because we're going to have a rise in clients.
Thank you.
Further questions? Chairman DeGroot.
To inquire the witness. Thanks for being here. I appreciate your testimony. I'm just a little bit confused. I'd like you to respond to this. You heard 4 or 5 sheriffs get up, who I thought were all very credible, testify that instead of going back to their jobs, they go out and commit new crimes.
Sure.
How do you respond to that?
Sure, and not having the individual facts, Representative, I can't address each particular circumstance. What I can say is that sometimes there might not be probable cause to hold a person. So if there's not probable cause to hold a person, that might be an explanation for why a person is released. There might have been a finding that the person was not dangerous, and then they get brought back in. I can't specifically address each individual circumstance, but what I can say is that this is why the Supreme Court created these rules, because we don't want to lock up people who are not dangerous, and we want to ensure that the people who are a flight risk or a danger to the community are kept detained.
Yeah, I don't either, and I understand all those stories were anecdotal for the most part, as are yours, right? I mean, we have to draw on your experience as a public defender to tell us what's going on in the streets, but we have to rely on their experiences as well, and this is what they're seeing. So I appreciate you being here in a different perspective. Thank you.
Thank you.
Thank you. Any further questions for the witness? Seeing none, thank you so much for being here. Next witness for informational purposes only.
Thank you, Chairman. I think I can come in under 30 seconds.
Thank you.
You're welcome. Steve Young with Kansas City, Missouri Police Department, and the Board of Police Commissioners and Chief Smith wanted me to be here today to let you know we're not taking a position on the court ruling, but rather to say that going forward we would like to be a part of the conversation, as Representative Hill said is necessary. The public safety connection obviously goes without saying, but I also want to say that it is not uncommon in our city for people who have been released to turn right back around and be repeat offenders again. And not only that, but also to be victims of violent crime as well. So,
very good. I appreciate that. Please be sure to leave your information with my office. We will certainly make you part of that discussion, as well as anybody else who wants to be part of that discussion.
Thank you.
Further questions for the witness? Seeing none, thank you so much for being here, officer. I appreciate it. Any other witnesses to testify for informational purposes? The Supreme Court.
That's right. Lucky me.
Thank you so much for being here. Proceed when you're ready.
I'll fill out a witness form. My name is Patricia Churchill, and I'm here to testify for informational purposes on behalf of the Supreme Court of Missouri. And really strictly in the context of describing just the background of the development of the rules. I distributed a packet to some of the folks on the committee, and because I didn't have a chance to reach all of you, I just wanted to testify for informational purposes that, and I'll leave a hard copy with you, that this was a criminal justice task force that studied this issue for approximately 2 years, and it included prosecutors and defense attorneys and representatives of law enforcement, representatives from Department of Corrections and Department of Insurance and academics, and the rules were written in response to those recommendations. So I will leave that with you and be happy to answer any questions.
Very good. Thank you so much. Questions for this witness? Very briefly, Representative Tolson Reich.
You said you delivered a few or some, so will you be getting that information to everyone?
Yes, I dropped it off. I didn't get to talk to you, but I did drop it off at your office, and like I said, I didn't make it
must
to
not
every.
have-
No,
I
it
didn't
was-
know.
Right.
Okay.
So, and I'm going to leave a copy with the chair and make sure everybody has the opportunity to
Thank
have
you.
it.
I'll make sure that gets out to everybody. Representative Elbrock.
Would it be too much of a stretch to say or to presume that the rule still allows some of these judges that are giving out signature bonds, that they still have the authority to be setting cash bonds?
I think in fact, the letter that was written, one of the items in the packet is a letter from the tri-chairs of the Criminal Justice Task Force, and they do mention that this is not meant to limit in any way the discretion of the judges.
Okay. Just more or less just to set up a guideline so that they have to tell us why the person's getting a cash bond, right?
That's correct.
Okay. So we're hearing that a lot of judges are releasing these folks on signature bonds or whatever under the grounds that they're taking into account their ability to pay. Ability to pay is not the only factor that they're to consider, is that right?
That's correct.
Okay, so there's a lot of other factors that these judges ought to be considering, is that right?
Yes.
Okay, do we know if the Office of State Court Administrators intends to send out updates or educate folks or let some of our judges know that they stop sitting all these signature bonds, please, because bad people are getting out? Is there any kind of...
Right. Well, there is a judicial education committee, and in terms of judicial education, that includes not just our judges, but our circuit clerks, et cetera. But the judicial judge aspect of that education, I'm sure that would be included in that.
But one of the things when we're considering the ability to pay these defendants might result in smaller bonds being set by the court. Is that a fair assessment?
That's potentially correct.
Thank you.
Thank you so much. Further questions for the witness? Seeing none, thank you so much for being here. Anyone else here to testify for informational purposes only? Seeing none, no. Representative Hill, we've been dying to hear you close.
Yeah, it's not going to be a stellar close, but this has been great conversation. I really think that what was missing over this whole issue is public comment. And I really, really would urge them. They could do this tomorrow to repeal those rules and allow us to move forward now and come up with good reforms so that, A, people don't have to sit in jail pre-trial just because they're poor, and B, the public safety, the victims of crimes, for the reason they are even in jail pre-trial, can be secure in the fact that they know they're not going to be reoffended. Because this whole conversation has been about the defendant and not about the victims. So thank you very much. I appreciate everyone's patience. This has been great. Thanks.
Thank you, Representative. This concludes our hearing on 1937. We have one more bill. I feel so bad. Representative Roberts, we will hear your bill, House Bill 1341. I know you said it's very brief, so come on up and get started when you are ready, sir.
All the encouragement really made me feel much better. I know it's late, and I know that some members of the committee are not feeling well, so I'll make this as quick as humanly possible. I'm bringing Lane Roberts from District 161. I'm bringing this item before you as a result of having had conversations with victims of stalking wherein the perpetrator stalked them using technology. I spoke with a number of other people and found out that this is more commonplace than perhaps we all understood. As a result, that brings me to address Section 455.10.010 RSMO, and specifically subsection 14 dealing with stalking. And what we have done here is try to address the question of being able to broadly deal with the